Hello, dear friends, welcome back. This is Indus Lex, and today we are going to discuss how much efficiently we can use the writ jurisdiction. It is a very prominent jurisdiction that the writ means of a formal order is given by the top court, that the constitutional courts include high courts of the state and Supreme Court of the nation. By using the writ jurisdiction, a citizen can protect their right from infringement by act done by a state. Five type, that is mandamus, where court issue direction against any respondent, that is state, or against the to the any employee of the state to do something or not to do something. Where the certiorari is the writ where high courts or Supreme Court quash, by using certiorari, quash the order passed by any executive officer. Habeas corpus is one of those writs by which you can protect your personal liberty. Writ jurisdiction plays a very vital role in day-to-day functioning of the administrative system administered by the state. So, dear friend, when we can get the benefit of the writ jurisdiction, how we can use this jurisdiction? First of all, we have to understand that in part 3rd of the Constitution of India there is a fundamental rights and 6 different types of fundamental right, that is right to equality, right to freedom, right against exploitation, right to freedom of religion, right to cultural and educational rights, and one most important right is given in part 3rd from article 12 to 35 is article 32 of the Constitution of India. Article 32 is a constitutional remedies as given as a fundamental right. Article 32 is given to the citizen for protecting their fundamental rights. It says that if there is infringement on the fundamental right of a citizen, he can approach the Honorable Supreme Court under this article for protection of the fundamental right. And in the same manner, article 226 has given the power to the high courts to protect the fundamental right as well as legal right also. And when this legal right comes into the play, you have to be very vigilant that suppose that you are a government employee, you are a student, you are working in some type of corporation which is managed by the state. If any action is taken against you, this must be given the opportunity to be heard. There is two basic principles of principle of natural justice, and it must be in our mind. That first one is, no one can be judged in his own case. Suppose that if any officer is become angry on you from your conduct, then maybe he has power to suspend you, but without giving notice he can't do so. If you are a student and you are not allowed to be sit in exam, to take examination, on the basis of that your fees is not deposited or your attendance is not up to that extent which is under the law, and therefore you are denied from taking the examination. So as a student where university or a college do such act which is arbitrary, which is illegal, legal although not justified in the eye of law, in a manner which that was conducted, then you have a right to approach to the high courts to protect your legal right directly. Only you have to see whether these rights incurred from any statute, like right to fair investigation. Every victim or informant of a criminal case has right to fair investigation. Suppose that a FIR is lodged by an informant and there is a two people, one is informant and second one is accused. If accused come to the high courts saying that look, there is no proper investigation, high court may dispose of the petition and said to the petitioner, look, there is alternate remedy under section 156(3) CRPC. You have to go there and tell the magistrate that investigation is not going properly. Magistrate took action. But when informant come to this court, it is her right, that right of fair investigation. It is in the statute, and therefore High Court directly entertained the petition. It is not such that prayer of accused for the fair investigation is not to be entertained by the High Courts at all, but the degree of acceptance of the petition, that the order you get in your favor, it depends upon the which law you come on or which ground you plead before the court. In the same manner, if you are a common citizen and government is acquiring your property without giving notice to you, then you have a right to come before this court, that is High Courts. Furthermore, suppose that you are a corporation or a company, a private limited company, and you supplied several products as a business player to the institution such as AKTU, APJ Abdul Kalam Technical University. Suppose you have supplied the goods like table, chair, board, whiteboard, and it is of some sort of 20 crore rupees. That amount is admitted now. And suppose that the state, being a university, being a state, paid you 90% some percent of the amount, and about 10% is unpaid for several years, almost 3-4 years. Then you have a two right. One right is that this is a business dispute. You can file a money suit. You can go for arbitration. You can invoke the jurisdiction of commercial court. But when you have state against you, state is a duty bound to pay the admitted amount. State cannot work like a private player. State has a very higher duty and obligation, and therefore where the amount is admitted, it is a very recent judgment of 8th January 2025. Honorable Supreme Court held again that if amount is admitted, writ jurisdiction can be invoked. High courts are not justified to directing the petitioner for alternate remedy in the law, meaning thereby where there is a state, you have a right to invoke your writ jurisdiction for the protection of your right or on the infringement of your legal rights. Further, suppose that your case is pending in the trial courts, in a district courts, in a executive courts, you can come before the high courts for expeditious disposal of the case. Another writ can be filed by the adult couples who want to live together their entire life, but due to some circumstances, some other people are not agree to this relationship, and then right to choose, right to marry, right to live, Article 21 fundamental right, and to protect their fundamental rights, you people can come before this court and ask for the protection. And definitely High Courts and Supreme Court, being a constitutional court, protect you. For the writ of habeas corpus. Writ of habeas corpus is used for those people who are illegally detained by the police or by some other person, or a man cannot be found from several years or several months, then the writ of habeas corpus can be entertained by the high courts. Habeas corpus means there is a corpus which is not available to their guardian or to their loving one. That corpus is illegally detained by someone, and therefore High Court direct the authorities to find out the body and to produce the corpus before the court. Even for the habeas corpus, High Courts and Supreme Court can be worked in night. The registrar office for this type of petition is open for 24/7 hours in our High Courts and Supreme Court. So dear friend, be vigilant, because as the country is going on, there is a scene of recession. There is less fund left to the government, its organization, and therefore it is a very high time for the government for not paying your payment, your salary, even for that the government may forcefully retired you, or in a day-to-day businesses you have to get some work from SDM office, you have to get some work from commissioner office, you have to visit tahsil, and in all these matter you have to be in mind that you can control your case at district level or a tahsil level or in collectorate office or in commissioner office by way of invoking Article 226 or Article 227 as a supervisory jurisdiction of the courts. A very interesting matter where you can also invoke Article 226 is for quashing of FIR. When a criminal case is lodged against you and you have a solid proof that it is a false case, your defense is very strong, or the ingredient of a section is not meet out, or it is a completely lodged by abusing the process of law, you may file a writ petition praying for quashing of the said FIR. In another case where you come before the Honorable High Court is that suppose that there is a criminal case pending against you and thus your passport application is not forwarded by the passport regional officer and returned to you by comment with the comment that a particular criminal case is pending against you, or your renewal of the passport is stopped by passport regional officer, whatever the case may be. It may be you applied first time, or it may be you applied for renewal of the passport. During the verification, if there is NCR or FIR and passport regional officer is denying to do your work on the basis of said case crime, then dear friend, please remember that NCR is no complaint at all if the magistrate has not taken cognizance on that. In the same manner, mere lodging of criminal case is not a ground to not issuing the passport, and therefore you may come before the Honorable High Court to protect your right of Article 14 reasonableness, Article 20 right to move, right to live, and in the same manner Article 19. And this right incurred from Menaka Gandhi versus Union of India passport case. Those who are interested can read the judgment. So after questioning of FIR, after protecting the couples, adult couples, after protecting your property rights, that when state can directly come and acquire your property without following the legal procedure, writ can protect you from the arbitrary action of your bosses, writ can protect you from delaying of the court procedure, and in several manner you can use the writ jurisdiction. Only one thing must be remembered: you can use writ jurisdiction only when there is state. In some cases, High Court may entertain the writ petition even against the private person, but that is very specific cases where the act of that person, even in the individual capacity, has some nature of the state, or a gross violation of human right is there. In such cases, writ petition can be entertained. Basically, writ petition come from Article 32 and Article 226. It is for the protection of fundamental rights and legal rights. Whenever a state authority is denying any application, in working on in any application given by you, you may approach to the High Court, or if any case is pending before any competent authority, you may come for before the High Court under this article, get some extra views, get some extra attention this court on that authority, so the authority may done the work properly. Article 226 is a very vast, even is entertained by courts when there is a committee of management of several institutions, several colleges, and there are several employers whose salary is not given to him. It doesn't matter that in which office your work is there. It is the jurisdiction to protect you and your fundamental rights from the arbitrariness, unreasonableness of the state. So for today, the writ jurisdiction, and in brief, I also want to know you that we are working on the abolition of Section 69 Bharatiya Nyaya Sanhita, and another issue we are added in our mission in this year, that every citizen has right to videography the trial procedure, and this right must be given by the top court to the citizen of this nation. Thank you. Stay tuned with us. Please subscribe our channel.